You know, Ms. Anand, the fact is, let's put aside the Places of Worship Act 1991. I want to, because there's a lot which has been written and lot, which has gone down in print when it comes down to the 5-judge bench, Ayodhya judgment. Now, it's a landmark verdict. I would reckon every Places of Worship, which is going to face a dispute will go back and the judge would refer to the Ayodhya bench verdict. And when you read through that, and there's so much written, it essentially seems to, lay down the law for the future, where it says non-retrogression is a legislative instrument designed to protect the secular features of the Indian polity, which is the basic feature of the Constitution. Will this also be an issue going ahead, this particular judgment, the Ayodhya judgment?
Of course, the Ayodhya judgment is extremely relevant for purposes of determination, and it is something that would be looked at, considered, pondered over, and ultimately analyzed in order to see how the same would apply in the facts and circumstances of the present case. It can never be said that it will not be. The extent of the application, however, would vary upon what emerges from the reports, what emerges from the application of the Places of Public Worship Act, as I said, and whether it applies there or not. You do know that one of the arguments which is made is that this act was never intended to apply to the Kashi temple and the Sringarma temple also. So these are some of the arguments which will have to be considered, but be that as it may, the factum of its relevance, the Babri Masjid judgment and the Ayodhya judgment, would definitely be predominant in consideration of this case.
Would you, constitutionally, because it seems to be a conundrum for, you're the better judge of that, but would you think the safest route, or if the government really wants to go ahead, because now the government is speaking, just the safest constitutional route, because there is majority where the Lok Sabha and Rajya Sabha is concerned, that the government, if it wants to go ahead with what is happening in Varanasi, what's now starting in Mathura, to go ahead and scrap the Places of Worship Act 1991. Would you think that would be the best way to go about it?
I don't like to step into the shoes of people who are to decide and the senior people who are to decide, but I can say this, that indeed when the act came into being, it came into being at the Narasimha Rao government, indeed at a time when the Ayodhya dispute was at its peak, and indeed it was brought in obviously and so-called, let's put it like this, vested interest. So if the government indeed feels that it doesn't fulfill a constitutional objective, if the government feels that ultimately it doesn't have an adjudicatory mechanism and therefore suffers from arbitrariness and unconstitutionality, and the violations themselves are in issue, it is of course always open to the government, and the government should consider such an option, because it did come under protest and without any consideration, without any deliberation, without any reference to the select committee, and therefore I think it definitely requires a relook.
On the 13th, Ms. Anand, 13th of March 2021, the Supreme Court had asked the centre to respond to a plea challenging the Places of Worship Act. The centre is yet to file a reply on that. Would you think that, this shows that the government possibly is reluctant to disclose its cards, or it's the legal cause?
It's a legal course. I mean, government takes some time to consider, ponder, decide what stand it is to take, and we've done that enough times. I appreciate, and in fact it's a very well considered aspect. If there is no immediate response to a petition, rather there is a well thought out and reasoned response by the government, which shows that the government is applying its full mind to the issue in hand, and what needs to be really considered is whether the act itself is constitutional or not constitutional. Thereafter it is in any case for the court to decide that if it is unconstitutional, the same has to be struck down. The other option is for the government to consider and to strike down the law and to repeal the law if it so feels.
Will it be legally considered, ma'am, that because of what is going down right now, we are standing at the precipice of opening up a Pandora's box of, if we give legal sanctity to what is happening in Gyanvapi, what's today has happened in Mathura, that it could just blow up because there are already multiple petitions in multiple courts?
I'm afraid when there is a disputed issue such as this, and it affects lakhs of people, and the question of ultimately faith and the freedom to practice religion, of course, which is a constitutional right, whether a spate of petitions comes or not, whether it opens a Pandora's box, I don't think we have to look at the net what is to come out of that precipice or to be at the precipice. What you are looking at is the issue has to be resolved. So the Supreme Court is in any case seized of the matter. The issues would substantially be somewhere wavering around this broad issue, and so ultimately a decision has to be taken. Having a panoply of, let's say, petitions coming up before the Supreme Court or other courts is not really the main target. The question is it right or is it wrong?
Ms. Anand, I'll ask you just two more questions. The fact that now there is clearly plausible evidence which might be sealed, but you know, the lips of the commissioner weren't, so he's gone ahead and given all these interviews. So we do know that there's plausible physical evidence of Hindu relics inside the temple. Now that all of this is as evidence submitted, what happens legally? What do we see? What's going to be the conundrum that possibly the Supreme Court will face tomorrow?
I think, Preeti, we've already gone through some of that, but let me just repeat some part of it which addresses your question. To say this, that what is before the Supreme Court and what will be argued, I assume, is the fact of the relevance or the constitutionality of the Act itself, the application of the Act to the Kashi temple and the site in question. The question ultimately would revolve around these issues, and definitely the evidence that is collected and which appears to have come, as you rightly said, it appears to have come forth that there is a shivling and there is enough evidence to indicate that a temple did exist. So therefore, it has to be considered in that backdrop. But in the meantime, whether the Act itself will sustain itself, if it doesn't, then the question of giving the Hindus the right to worship the shivling in the area in question can hardly be a disputed issue.
Ma'am, my last question, which really doesn't have much to do with the case, but there is a lot of questions, like I said, because it's got the nation's imagination, is the two-judge bench that is hearing this petition. One of the judges was a part of the Ayodhya judge, the five-judge bench. The other one was a lawyer for the Hindu side at one point of time. Does that in any which way come into play? Because we're getting a lot of questions being asked on that as well.
I think we have to trust the fact that the judges who are hearing the matter, if they were part of the Constitution bench, they definitely took a view in the facts and circumstances of that case, and there is no question of there being any questions asked on that account. We do have full faith in the judicial consideration of the issue in hand, and even if there were judges in the Constitution bench itself, would make no difference. On the contrary, it is something which has to be considered in any event. So I don't think any focus could be put on that kind of issue or perspective.
Ms. Pinky Anand, appreciate you taking the time out. Thank you for joining us. A lot of people have a lot of legal questions and all the rhetoric that is going down. Thank you for joining us this evening, Ms. Anand.